Minister. I don't have the Minister Golden is with us this morning.
What mic is on? You can hear them? No, we're ready now?
Yep. Okay. Good. You want? Okay. Good morning, colleagues in the media and the viewing public on PBCJ. We want to welcome you to our weekly Jamaica House media briefing. Today, Wednesday, July 24. My name is Lincoln Robinson. With us this morning, we are very pleased to welcome the Minister of Justice, Senator the Honorable Mark Golden. You'll be hearing from him in a moment. And we have, as always, our Information Minister. First off, though, we take a look at some of the issues coming out of the Cabinet this week, and then we will hear from Minister Golding. Over to you, Minister.
Thank you, Lincoln. Good morning to our viewers on PBCJ and to those watching us on the Internet, and good morning to the members of the media here. Cabinet has given approval for the implementation of the initial recommendations for improving the procurement process of the Government of Jamaica. Over the last 18 months, the Cabinet Infrastructure Subcommittee has observed protracted delays in the procurement process. Recognizing the negative impact this could have on the economy, stakeholders arrived at a number of recommendations to improve the process. The core recommendations are categorized under 4 pillars: legislative and regulatory framework, institutional framework and management capacity, transparency and integrity of the procurement system, procurement operations and market practices. Cabinet also discussed administrative sanctions to hold procuring entities and the approval bodies accountable for delays in the procurement process, developing procurement expertise across government, and the work of the Procurement Appeals Board. Cabinet has given approval for the bill entitled Security Interests in Personal Property Act 2013 to be introduced to the Houses of Parliament. The Act is designed to implement a legal framework by international standards to modernize and improve the availability of domestic credit to the private sector while minimizing the risk of repayment of loans. It also seeks to create security interests in personal property, simplify the registration process for recognition of such interests, allow for public notification of security interests, and stipulate the rules which govern the propriety in which such interests are enforceable. The current collateral systems in Jamaica is costly, inefficient, and not in keeping with best practice standards. This bill paves the way for business assets to be pledged as collateral with greater reliability and certainty for recovery. We believe the passage of this act will increase access to credit and enhance the business environment. Cabinet has approved proposals to amend a number of laws and regulations in order to reform the practice of probate and administration of estates in Jamaica. Cabinet has also authorized that drafting instructions be issued to the Chief Parliamentary Council, and the Minister of Justice is here and he will explain more later on. Cabinet has approved the award of a contract for the lease of laboratory and analyzing machines with the purchase of reagents for 3 years for the Spanish Town and Linstead hospitals. The contract has been awarded to Lasco Distributors in the amount of $107.45 million. The Spanish Town Hospital is a 600-bed facility that provides medical, surgery, urology, radiology, pediatrics, and pathology services, among others, to over 160,000 patients. The Linstead Hospital has 60 beds and has an annual patient load of just over 30,000. Cabinet has approved the award of a contract to Noel Mobile Systems GmbH for the supply and commissioning of 4 diesel-electric straddle carriers for the Kingston Container Terminal. The contract is valued at €2.79 million. A straddle carrier is a non-road-going vehicle used at ports for stacking and moving containers. The purchase of the equipment will be funded from the Port Authority of Jamaica's 2013-2014 budget. And the Prime Minister will next Wednesday officially launch the Partnership for Jamaica with the signing of the agreement by representatives of the private sector, the opposition, trade unions, and the Jamaica Civil Society Organization. The Partnership for Jamaica is the outcome of a process towards a social partnership for the nation in which the government, opposition, the private sector, trade unions, and civil society are involved. The agreement to be signed next week has been framed with the participation of the representatives from all sectors mentioned. The agreement represents the consolidation of years of work to build a social partnership of all the major sectors. And it's a short briefing we expect today, and we're now going to open the floor for questions. But before we do so, I'll ask the Minister to explain a little bit more about the probate on estates.
Thank
Minister.
You. Thank you, Minister Faulkner. Before I get into the probate, I just want to mention that the security interest in personal property legislation, which you mentioned, has been tabled in the House. And it is actually a structural benchmark. The deadline for tabling it was August 31, and it was tabled last week in the House. And it represents the fifth piece of legislation that has been brought to Parliament in compliance with the deadlines set out in the agreement made with the IMF. Cabinet approved legislation to be prepared to modernize and eliminate some of the anomalies that now exist in the laws governing administration of estates of persons who have died. The law and practice of probate and administration of estates in Jamaica has not been significantly reformed for over 100 years, with the exception of the probate rules of court, which were brought into force by the Supreme Court Rules Committee in 2002 and were amended in 2006. Over the years, the system inherited from our colonial past has struggled to satisfy the demands of a growing population in an era when processes are expected to facilitate efficiency and expedition. The result of inadequate resources and archaic laws and procedures is that there is a substantial backlog of applications in the Supreme Court, the resident magistrates' courts, and the Stamp Office, and members of the public are often frustrated by delays in concluding the probate and administration processes. One result of these efficiencies is that a significant number of parcels of land and other inherited assets, such as money in bank accounts, cannot be transferred to beneficiaries. Executors, personal representatives, and administrators, discouraged by the protracted and confusing processes in the courts and other departments of government, either leave these estates in abeyance or completely abandon the efforts to complete the administration of the properties that form part of these estates. And what we have done is we have identified a number of reforms that collectively can make a significant difference in this regard. I'll just mention some of them for you this morning. A simple one is an amendment to the Judicature Supreme Court Additional Powers of the Registrar Act. It has been determined that a significant contributor to the delays experienced by applicants in the Supreme Court is the fact that, at present, only the Registrar can sign grants of probate or letters of administration. It is proposed to amend Section 3 of the Judicature Supreme Court Additional Powers of the Registrar Act to confer powers on a Deputy Registrar to sign grants of probate and letters of administration. By empowering the Deputy Registrar, it is expected that these delays will be significantly lessened. And it should be noted that Deputy Registrars are legislatively empowered to sign other orders made in other divisions of the Supreme Court. So the current position in the probate division is somewhat of an anomaly, which will be corrected by this. In the resident magistrates' court, there is some confusion in relation to the applicable rules to be followed when you are applying for probate or letters of administration in the resident magistrates' court. A legislative amendment will be made to make it clear that the processes that were developed for the Supreme Court in 2002 and amended in 2006 will also apply in the resident magistrates' court with such adjustments as may be appropriate. An important change is to the Administrator General's Act. Section 12 of this Act is going to be amended to remove the need for the Administrator General to apply for a grant of probate from the court in the case of intestate estates, that is, persons who die without making a will, where minor beneficiaries are involved. And also in the case of testate estates, i.e. where there is a will, but there's no executor appointed or willing to prove for probate. The Administrator General will be empowered to issue an instrument of administration, which is to have the same legal authority and status as a grant issued by the court, and to proceed to administer the estate once the instrument of administration has been issued. This amendment will significantly reduce by over 1 year on average the time that now elapses before which the Administrator General can commence to administer an estate, and will also reduce a significant burden and backlog in the probate division of the Supreme Court. Another change that is being made is to allow the Administrator General to proceed to distribute assets to known beneficiaries without the need to obtain a grant. Presently, this only applies where the assets are less than $50,000 in value. That was set many years ago in 1999, and that is being adjusted and increased to $500,000. So if assets are less than that figure, the administration can proceed, and the distribution of the assets to the beneficiaries can proceed right away. Similarly, in relation to personalty, that is, assets other than real estate, presently, if those assets value less than $100,000, they can be distributed to the beneficiaries without the need of a grant from the court. And that ceiling will also be increased. It was last set in 1999 and will be adjusted again to $500,000. There will be a change to the Intestate Estates and Property Charges Act to recognize that a child that is in the womb can be treated as a beneficiary as long as that child survives the death of the person, the intestate person, and the paternity of the child is established. Presently, the Act excluded children en ventre sa mère, which is the legal French term for a child in the womb, from being eligible to participate in the deceased estate on their birth after the deceased has died, and that will be changed. We are also going to be, procedurally, we're going to amend the Probate of Deeds Act. The Probate of Deeds Act presently requires a notary public overseas when they are certifying deeds that were signed abroad. They have to also be accompanied by a certificate from the authority that appointed the notary public, stating that the notary public's commission was duly authorized, and that is a significant inconvenience for persons abroad dealing with our courts, and we're eliminating that requirement of this additional certificate. We're also going to be under the Probate Resealing Act. Resealing is the process by which a will that was made abroad and has been approved abroad can be brought into Jamaica with their assets here and is certified by the court through a resealing process, and which allows the assets locally to be administered. Presently, that facility is only available under the Probate Resealing Act where the grant was issued by a court in a country that's a member of the Commonwealth or a British court in a foreign country. This amendment will allow resealing for grants by the court in any jurisdiction. We are also going to be amending the Wills Act, and this is an important amendment which deals with a situation where a person who has attested the execution of a will by the person who made the will is automatically, under the current law, deprived of any gift given to that person in the will. And Section 10 is to be amended so as to allow that beneficiary to apply to the court, and the court will have authority to determine whether or not to uphold the gift. This is considered necessary because you have instances where people simply don't know the rule and attest to the signature by the person making the will as an attesting witness and get deprived by operation of law of any gift in that will. And this will allow the court to review the situation and to see in an appropriate case whether the will can be upheld and the gift can be upheld. We're also going to be amending the Judicature Supreme Court Act, and this is to allow some of the fees that are payable in the probate process currently have to be paid at the stamp office. And we are going to be adjusting that so that those fees can be paid at the court itself, and that will save time and reduce some of the steps that are presently holding up the process for these estates. So these are a clutch of measures that collectively should reduce some of the delays in the administration of deceased estates in Jamaica. It is a source of frustration and injustice, and indeed it is retarding of economic growth and development, where you have assets that cannot be dealt with by beneficiaries on a ready basis. And so we are, in recognition of that, we have done an analysis of all the laws of Jamaica that impact on this process and are seeking to reform in the manner that I have discussed earlier to facilitate an easier process and enhanced efficiency and making those assets productive again for the families involved. Thank you.
Thank you, Minister Golding. And we will now open the floor for questions.
Larry?
Can we get a microphone to Darren?
Thank you very much. Good morning, ministers, colleagues. I won't start with the amendments you have proposed, Minister Golding. I wanted to get from you in relation to, I want to go to the cigarette ban, because Cabinet would have discussed this. And can you tell me whether, what is being done if you plan to bring it back to the Parliament, and in that time, will you be suspending the ban to accommodate the discussion in the Parliament?
This matter has been discussed at Cabinet. The Minister of Health has assured the Cabinet that he is going through a process of consultation with affected stakeholders on the recently promulgated regulations. And I think he's keeping a very open mind on the issue, while he's very resolute that it's important that we do eliminate smoking from public places and so on, because it's a public health issue which has significant impact on the health of the nation. He is prepared to look at all of the concerns and to be guided by that process. So he has assured us that that is going to be pursued, and a small group within Cabinet has been appointed to liaise with him on some of those issues, and so that we can determine how to move forward with them. I can't say much more about it than that.
But if I may go a bit, so isn't it the thinking of the Cabinet that perhaps it's untidy to do the consultations after you have implemented, and perhaps you need to put the implementation on hold to tidy up the loose ends?
Actually, I think sometimes it spurs action when you act. And in this case, the minister acted in a decisive manner according to a time frame that he had committed himself to. And this is a matter which has been dragging out for many years, and he has been able to bring it forth quickly. Now, that is the process going to involve some adjustments? Perhaps. But I think, as I said, he's open to considering all the issues that have been raised, and I have confidence that at the end of the day, we will end up with a regime that the population as a whole feels is reasonable, well-balanced, and for the benefit of the nation.
And if I may, Minister Golden, he also has given the assurance that he will come back to the country in short order to say what the decisions are as a result of those discussions.
Mr. Gordon, again, as it relates to the justice system, perhaps some serious commentary can be made about the justice system. The DPP's report, latest one, pointing to 30% convictions in the gun court. We're talking about high-profile cases where people are walking free based on the evidence that has come before. Are you concerned about the integrity of the justice system? Perhaps it's tied in with also your colleague, Minister of National Security, on the investigative side. But what confidence can the people of Jamaica have in the justice system when a lot of the statistics are not showing as if the investigative work is being done to secure convictions?
Well, the role of the justice system is to ensure that those who ought to pay for their misdeeds do pay, and also to ensure that those who are innocent in the eyes of the law are not convicted and are set free. So, for example, we had a situation this week where in that heinous act that took place, I think in Irwin, was it
Irwin,
St. James,
Mm-hmm.
two citizens who had been charged with those offences have been set free. Now, to my mind, that shows that the justice system has worked, because DNA tests were done which showed conclusively that they were not the persons involved, and they were acquitted and released based on that evidence, when other identification evidence was not forthcoming that could have supported the case proceeding. Obviously, one hopes that the perpetrators of that act will be identified and will be brought to justice. But the fact that somebody has been released through the justice process, where innocence was there was obviously no basis for conviction, is a good thing. In terms of the statistics shown in the 2010-11 report of the DPP on convictions in the gun court, there are a lot of challenges in terms of proceeding expeditiously through the criminal justice system. One of the challenges has been the forensic lab and the capacity of that lab, which in gun court cases is important, because often ballistic certificates and other forensic evidence is very important. And if you have a protracted delay in getting cases to trial, then other aspects of the case can start to fall apart. Witnesses and so on may migrate, their memories will fade, and all the rest of it. So what we are trying to do is to strengthen the forensic lab and its capability, and there have been improvements. They have additional equipment. The time frame for the issuing of ballistic certificates has been shortened significantly, and that should assist in having timely prosecutions of those cases. In terms of the overall integrity of the justice system, I believe we have judges who are committed to the process of justice, who are competent judges, and are generally held in high regard by the citizenry. We have a constitution and laws that are based on fairness in our procedures. What we need to do is try and focus more on efficiency, and that is where I think the justice program, the law reform, the justice reform process that we are undertaking will, over a period of time, bring significant improvements, because there are a number of different interventions which are being pursued to try and improve the efficiency of the system and to bring justice to the people.
May I have a follow-up on that, Minister?
Sure, go ahead.
The issue of damages, injury to people's reputation, isn't that something that concerns you? Look at the conviction rate. It suggests a lot that these people, most of the people who are being locked up, there isn't a basis for them to have been locked up in the first place. And then also in terms of, there's a Tesha Miller, for example, who has indicated that he would be filing, he will be seeking damages from the court, and so on. And we have repeated cases of this. I think it has also been said in the case of the Irwin brothers. Aren't you worried about that aspect of it?
Well, in our system, anybody can bring a lawsuit for anything. It is for the court and the processes to sift out those that have merit and those that don't. And we also have a system of costs, where persons who bring unmeritorious claims have to pay the costs of the other party. And that is designed to be a disincentive to have frivolous or vexatious claims or unworthy claims brought in the courts. Now, I don't want to speak to any specific case, because if it's before the court, it would be inappropriate for me to do so. But I just say the fact that somebody is acquitted at the end of a trial does not mean that that person has any basis for bringing a lawsuit against the government or the state for having commenced those proceedings. As you know, the standard of proof in criminal matters is proof beyond reasonable doubt. And at the end of the day, an adjudication is made by a judge or a jury, depending on the nature of the case, as to whether that threshold has been, which is a high threshold, has been surmounted by the prosecution. The fact that an individual judge or jury may not feel that that threshold was passed does not mean that there wasn't ample grounds on which to bring the case and prosecute the case. And a person faced with that situation, if acquitted, has the benefit of having been acquitted and the vindication of that. But in terms of having a right to claim damages against the state, that's an entirely different matter.
Do we have any other questions? No? Okay. We did say it was going to be a short briefing.
Janella?
Thank you, everyone, for coming. Remember, we won't have any briefing. We won't have any briefing next week because we're signing the partnership agreement, and it clashes with this time. So have a good week, and we'll see you soon. Thank you, everyone.
Good.